Well, good afternoon, everybody. I'm Dawn Medesey with Oxford Township Parks and Recreation. I may have talked to some of you on the phone or took your registration. So welcome to the Oxford Senior Center. I'd like to welcome Wendy today from the Manor Law Group, and she will continue doing introductions from here. So thank you all for coming.
Thank you, Dawn. Welcome, everybody. We appreciate you here. Just want to introduce our attorney. We apologize. Bob Manor woke up feeling very under the weather this morning. So Kelly, however, is a pro. So you guys are in good hands. She's excellent. So Kelly, actually, she's our attorney in our office. She oversees Manor Law Group's legal planning and operations. She does bring vast estate planning, probate, and trust administration experience to Manor Law Group. Kelly is a certified dementia practitioner. She's also an accredited attorney through the Department of Veterans Affairs. She's the Office of General Counsel of that department. Currently serves as the president of the Michigan chapter of the National Academy of Elder Law Attorneys. She's an active member of the Michigan State Bar Elder Law and Disability Rights section, as well as the Probate and Estate Planning section and Real Property section. Kelly has presented on various estate planning and probate topics, including presentations through the Institute of Continuing Education. A little bit about Kelly. She is a graduate of Central Michigan University and obtained her law degree from Michigan State University College of Law. So she's the smartest, and we're proud to have her on our team. So Kelly King-Penner.
I knew this was going to go off as soon as I got up here, so let me get this set up for you guys real quick. Thankfully, I've done it about 5 times now, so I know how to do it.
All right. Well, thank you guys so much for coming out here. This presentation is largely about what you guys want to know. So I welcome questions throughout this entire thing. If there's something and you have a question on it, please don't feel like you have to wait till the end. I prefer to have a lot more interaction in this. Otherwise, it's just me listening to the sound of my own voice, which I don't love. So if at any point during the entire presentation, feel free to ask a question. If it's something of a more personal nature that you would rather talk with me after, feel free to do that as well. I will be around for a little bit afterwards. And if we're getting into kind of that question where I think it's something we should kind of talk at the end, I'll let you know as part of that as well. But I do welcome questions throughout the entire presentation. So what we're going to talk about today is kind of 3 action steps that we should consider right now. So there's always things that we can be doing in this area, particularly as we continue to age. So the estate plan that you guys had early on, maybe when your kids were little or young, probably is not what's going to be appropriate for you going forward. And there are some different considerations that we have to look at as we continue to go through that aging process as well as the law changing. There's been a lot of changes over the last decade that has made estate planning much more complicated and much more confusing, but I'm hoping to kind of clear the field and give you guys some good takeaways today. So just as a general overview of what I hope to cover during this presentation, we'll go through different care options and how we go about paying for long-term care. So general overview of the benefit options that will be available. A lot of them are state specific, so I'll be talking specifically about Michigan law. There are a couple that are national, but for the most part I'm going to be going over the state specific programs. We're also going to talk about the different and updated estate planning documents that are available. Your estate plan is rarely ever one document. A lot of times I hear people focus on one particular document, but really it's about having a good comprehensive plan, and even then those are tools in the toolbox. So the documents themselves are helpful, but that's not the only thing that we often need when we're going through all of this. The additional thing is how to get access to additional resources and support. This is probably one of the more valuable sections because if you have a certain tool but you don't know how to use it, it's not going to be super helpful for you. So having an idea of the different resources and support options that are available for you will also be something that we touch on as part of this presentation. So this presentation definitely is for you if you are confused by what the future is going to look like. I don't know about you guys, how many of you have like a crystal ball at home where you know exactly what's going to happen over the next 15 years? Because if you have one, I'd like to know. I'll have a teenager by then, and I'd like to get in front of all of that. Most of the time, we don't know what things are going to look like. And when we don't know what things are going to look like, we can often get confused by the fire hose of information that's out there. So this presentation is definitely for you if you want to get some more clarity on if something happens, what should you do? Also, if you're scared about not being able to make your own decisions. I think this is probably one of the more common things that I see when people come into our office is that they want to make sure that the people that they love and trust can help them. And there's a lot of horror stories out there of different people or courts getting involved and taking things away from people. So we want to know how we can keep control and make sure the people we love and trust are the ones that are helping us and not having it end up with somebody we don't intend it to. As well as making sure that your estate planning is flexible enough to deal with future issues. So diagnosis is definitely one of them. We're going to focus a lot in this presentation about Alzheimer's and different forms of dementia, largely because we know that is becoming a growing concern. But we're not just limited with having estate planning that's just dementia and Alzheimer's focused. That's definitely one of the things we look at, but it could be any form of diagnosis. As well as if just circumstances change. The laws can change, your family can change. Flexibility with your estate planning is really one of the most important things that we look at. So your goals of planning, as I just indicated, having a plan that will grow and change with you. So there's things that I know about that are going to happen. I can look at the legislature and see possible bills that are coming in for new laws, look at the tax changes, all of those things I can kind of anticipate. Things in your family you may or may not be able to anticipate. You may not know that you're going to have a diagnosis. You may not know that the person that is your primary agent is going to have a health issue of their own and can't step in for you. So having that flexibility as things change is really important. Also, having a good plan makes it easier on our family. And having a good idea of how to navigate all of those hardships is really what's important for our family as well. There is unfortunately a lot of bad information out there when it comes to qualifying for different long-term care benefits or what you need to do in order to prepare. So there can be a lot of missteps. So we want to make sure that we're protecting everything so we don't become a burden to our families. We want to protect our families, especially I see this a lot with married couples. Nobody wants to put more pressure on their spouse than what they're already facing. Everybody's got their own personal needs. What is it they say? You can't pour from an empty cup. You both need to be able to take care of yourselves in order to take care of each other. So making sure that we've got a plan that we're not burdening our spouse or our children or our loved ones. So making sure everything is in place to make it as easy on them as possible. Also allowing them to kind of stay in those family roles as much as possible. Let them continue to be husband or wife or daughter or son without having to take on all the additional burden. Peace of mind. I would say we have a little intake form in our office and we have, what are you looking for as part of your estate planning? And peace of mind is probably the primary statement that I see on this, is people want to have that peace of mind that things are taken care of, that their plan is good, that they have a strategy to move forward if something goes a little off kilter. So peace of mind is definitely a goal that we're always looking at as part of this planning. So a little bit about myself. So I'm not just an automatronic attorney robot up here. I live in Fenton with my husband. It's Jason. Jason is a high school, middle school band and choir director. Him and I have known each other since we were 16. The little guy that's dominating all of this is my son, Benjamin. He just turned 4 on Friday. As you can see, he's quite the character. Very, very personality. I don't know how my husband and I, who generally are more introverted, gave birth to an extrovert, but we did. He's very social. So just an idea of our families and what we're looking for and what we're all looking to do as part of this is make sure everybody is taken care of. The same goal that I have in taking care of my husband or my son is the same goal you guys have as well. This is really just illustrative of the dementia care journey. So this is supposed to illustrate the confusion. It's kind of like that Chutes of Ladders, or sometimes it reminds me of Candyland, if you guys have ever played that with yourself or your grandkids. This is really to illustrate all the kind of ups and downs and navigating all the different things that you might encounter as we go through the dementia care process, but really any kind of health care process. There's a lot of ups, downs, slopes, slides that are going through, and trying to navigate all of this when you have really no level of expertise in all of this can be really confusing. Even in our office, we work with a team of people that have different expertise to kind of fill in the gaps for all of this. But it can be extremely confusing if you're trying to navigate this path alone. So that's what our office aims to do, is to make this as easy as possible for people to navigate this process. All right, so the first action step, and we've already kind of alluded to this, updating your legal documents. Maybe you don't have any legal documents. That's perfectly fine. There's no such thing as too late. But more often than not, I encounter people that have some form of estate planning. Maybe they did it 10, 20, 30 years ago, had a different purpose. A lot of times it's when they were younger, when their kids were younger, they want to make sure if something happened to them, who would raise their kids. So now we have to look at making updates to them, because our documents need to grow and change with us. The documents that served one purpose when we were younger won't necessarily work with what we're trying to achieve when we're older. And even then, sometimes you just did the documents, but maybe they don't do everything you need them to do if a healthcare crisis comes in. So we're going to dive into a little bit more about what we mean by updating your legal documents, as well as giving an overview on what these different documents do. It's moving out here, but not out here. Let me see if my cast stopped. Bear with me for technical difficulties. Stop it, and we'll just restart. In the event I can't get this to work, I will still load it up and get you guys everything. But I'm pretty sure I can get it. Wendy, what we might need is that HDMI cable, because it's picking up. It's just not picking up the cast, and I don't want to spend 20 minutes of your time sitting here staring at this thing. You got it? Do you know what number you're plugged into?
Nope.
We'll figure it out.
Usually 4, I believe.
Okay. I knew this was going to happen with me. It always does. I am Murphy's Law embodied.
So I want to go in. Want me to-
So like
probably
with the
got
USB when you put it in and then you turn it around. There we go.
There we go.
All right, back at it. So what legal documents do we need when we're talking about having a good estate plan? And remember, this is still going to change as things go back and forth, but there are some fundamental things that we typically look at for having a comprehensive estate plan. The primary one most people think of are powers of attorney. Powers of attorney is kind of an overview of a subset of documents. When we're talking powers of attorney, we're going to be talking about financial, so who would make financial decisions for you in the event that you can't. We're also going to be talking about healthcare. So in the event you cannot make your own medical decisions for yourself, who are the people that are going to step in and advocate for you on your own behalf, and then what kind of guidance they're supposed to follow. In Michigan, this is kind of a misnomer. I just like to talk about this sometimes. How many people have heard of a living will? Okay. It's one of my least favorite legal documents ever because it's really confusing. A living will is basically a healthcare directive. So it has nothing to do with a will, has nothing to do with like your estate or your assets, but it's a healthcare directive. Michigan doesn't have a living will statute. Instead, what Michigan has is something called a patient advocate statute. So you might have heard durable power of attorney for healthcare or power of attorney for healthcare, patient advocate designation. All of those are the same thing essentially in Michigan, and that's having a healthcare power of attorney that gives forth the person that you want to advocate for you and what kind of direction they're supposed to follow. So what kind of medical treatment you want or don't want, whether or not you want them to be able to sign a DNR for you if you can't on your behalf or talk to your physicians about it. All of those are kind of branch out as part of that. Similarly, powers of attorney for finances are also kind of a broad category as well. If you've seen one power of attorney, you've probably seen one power of attorney. They're not all made alike. Michigan doesn't have like a standard form that's in the statute that puts one out, at least not yet. They're currently debating it. But we have to look at the individual power of attorney for finances to see exactly what it does. And we're going to get into that a little bit more, so I'll just kind of touch on that a little bit. Last will and testament. This is probably the second most common estate planning document that people are familiar with is I have a will. Generally speaking, a will is a death document. We're only using that if you've passed away. The will really has no authority before that, and it really doesn't have any authority until a probate court gives it authority. So a lot of times people think wills make things simple and are really straightforward. Wills mean probate, essentially. So if we're relying on that, we're relying on that probate process through the court. Trust. So I get this question a lot. There are a lot of different kinds of trust, and they range from very, very simple and straightforward to very complicated tax planning tools. It used to be that people considered trust for really wealthy people, and most people didn't actually need trust. That's actually not true anymore. Sure, the wealthy still have their really complex tax planning trust. But most people, I found, want to maintain a couple of things. They want to maintain control with the people that they trust. They want to keep things with the family and not involve the court as much as possible. And they want to make sure things get to the people they intend it to without it going to the people they don't intend it to. So they don't want their beneficiaries to pay more taxes, or they don't want maybe a not so great daughter or son-in-law to receive things. So trusts are fantastic estate planning tools to achieve all those goals that I just talked about. And the vast majority of people, once you explain the different things that they do, actually really like them and find that they maintain all of those goals really well. They're also very flexible. So if things change, we can update them. So there's a lot of different kinds of trusts. There's even a couple that I'm going to touch on as part of this presentation, but they don't have to be super complicated. That's the nice thing about this. And they're actually just really great tools. You're going to hear me talk a lot as part of this about extraordinary powers. When we talk about extraordinary powers, it doesn't mean it comes with a cape and you're a superhero, although that would be cool.
Instead, when we talk about extraordinary powers, we're talking about certain authority, so the ability to do certain things as part of your financial power of attorney that allows your agent, the person that you trust, to be able to do certain things to protect assets for you if you're not able to do it. So this is especially important when we have a healthcare issue that pops up, that maybe we're not able to make our own decisions for ourselves anymore, and we need our loved ones to look at getting some benefits to help pay for care. And in order to look at those benefits, we need to be eligible for it. So there's things we might have to do to protect assets to make sure that we have some flexibility moving forward. We're going to get into a lot more about that. These next two I want to get into a little bit more because these are not basic estate planning. When I say they're not basic estate planning, I mean a lot of attorneys, when they're approaching estate planning, won't necessarily consider the dementia-specific planning or the pre-planning for dementia. Being that they will do really good estate planning for you. It will work in the event that everybody passes away in the right order and there is no major crisis. But if there's a crisis or something that pops up, we've got some missed opportunities. So we know, statistically speaking, especially when there's a married couple, if one of them has some kind of a health crisis, let's say dementia or Alzheimer's, statistically speaking, more than half of the time, the healthier spouse is the one that passes away first. So if that happens and everything is left to the spouse with Alzheimer's or dementia, they're not able to effectively manage their own estate. We might be looking at a situation where we have to do some kind of a spend down in order to qualify for benefits. So it's a missed opportunity that if we know this is possibly coming and we know the statistics are in our favor, that we can do some specialized planning ahead of time that if that happens, we've got a plan. And if it never materializes, then we still had a plan and we still have some really good estate planning in place. So if we know about it, and then also maybe we know about it early, or maybe we know everybody in my family has developed dementia. They are finding there's a little bit more of a genetic link with some of these. Everybody in my family has developed some form of dementia. I know that this is a possibility that's going to come up. I want to be able to pre-plan as much as possible. So maybe that's updating your estate planning to reflect that. Maybe that's also looking into other things like long-term care insurance, all things that are kind of more specialized in our area of law where we deal with this all the time. So we're looking at it with slightly different eyes. So the most important document, I want to get back to the powers of attorney as well, because these often seem like a fairly benign thing. You can go online a lot of times and find a power of attorney, go and get it witnessed, go get it notarized. But there are some major pitfalls with the financial power of attorney that I really want to hit on here. So basically, from a legal standpoint, just so we're all on the same page, a power of attorney is a written document. It's an act. There's no such thing as an oral power of attorney. I can't say, hey, Wendy, go to the bank for me. Tell them I said it's cool. They're going to need some kind of written documentation to show that this person has authority. Where one person, who is the principal, so the person who grants the authority is referred to as the principal, authorizes another, known as their agent, so the person who acts on behalf of another, to do certain activities. So when we're talking about the financial power of attorney, we're saying, I am granting Wendy the ability to access my accounts if I need it, the ability to make withdrawals from my 401k if necessary, the ability to sell my house or transfer it if necessary. When we talk about extraordinary powers, like I said, this is not something that is in every single power of attorney. There is no standard power of attorney in Michigan. These extraordinary powers require a little bit more explanation because this is in the document, in the financial power of attorney, we're granting your family or your agents, we kind of use family as our basics, but your agents, the ability to perform specific tasks necessary to protect agents and qualify for benefits to pay for your care. Now, it's not magic. We're able to give them certain authorities in order to comply with the safe harbors that are built within the law. So they're able to do certain things that are not normally included in a power of attorney in order to protect more assets. So you'll see those certain areas. Typically, those are involving
doing some kind of strategic plan under the law. I hate to give specifics because then people Google and they go down a rabbit hole. But that's generally speaking what we're talking about is this ability to do certain things that are allowed under the law to protect assets. So it's important that our powers of attorney, our financial power of attorney specifically, has these extraordinary powers in there, because what happens if we don't have that included as part of this? So hopefully, for those that come into our office and if they don't have these extraordinary powers, maybe we can look at updating, getting a new power of attorney signed. If the principal is still able to think about all these things and we can explain all of that, maybe we can get a new power of attorney and that solves our problem. If it doesn't do what we need it to do, sometimes we need to go to court and get permission. Court's never the fun thing because I'm operating on the court's timeline when it comes to this, and there's nothing expeditious about the court. If any of you have had any experience with either the probate court, the circuit court, any kind of traffic court, they are not fast with anything. So that sometimes can cause problems. So when we're looking at our estate planning, this is probably one of the most important things that we have. And this is regardless of whether or not you've done pre-planning or not. Because if something happens, we still need to be able to make sure we've got the greatest amount of flexibility as possible. So why is it the most important? This is the one thing that I like to touch on because this is just really good general estate planning knowledge. In Michigan, there is nothing that is commonly referred to as a general family consent law. So what a general family consent law does in states that have it is they will go kind of by a next of kin type thing, that if you can't make financial decisions for yourself or medical decisions for yourself, they're going to go to the next of kin. So my spouse automatically has the ability to do things. Can't tell you how many times I've had to explain to my husband that I can't just go do things for him. That's not how this works in the state of Michigan, simply because we're married. There's documents that have to be in place, and your spouse, just being your spouse, doesn't automatically get access to certain information. So if it's my 401k, my husband can't just call up and say, hey, we need to update this because Kelly's going through a health crisis. They're not going to talk to him. So it's important that we have these documents in place to make sure the people we love and trust have the ability to make decisions for us. Also, I'm one of 3 children. I love my siblings. We don't always get along. So with general family consent, sometimes it puts all of your children in a giant pool and they all have equal rights to things. Well, maybe you would want your son to make those decisions, but your daughter, maybe not the best for making decisions on healthcare. If we have an estate where there's those generally family consent laws, it can cause a little bit more confusion versus if we have a power of attorney that says, this is who I want to act, these are my backups, we have everything set forth. If we don't have these documents, I've already kind of alluded to this, where we're looking at court. And really those 2 court processes we're looking at is guardianship, and what that replaces essentially is a healthcare power of attorney. But it's a lot more broad than just a healthcare power of attorney. It essentially cuts off your ability to make decisions for yourself across the board. Somebody else is standing in and making decisions for you. Now they're supposed to look to you for things, but you don't have the ability to make decisions for yourself. Your guardian has the final say. With conservatorship, kind of the same thing, but you don't have the ability to make decisions with regard to your assets. Your conservator has it. So we lose some control when we're doing this, and then on top of this, the umbrella over all of this is your family might be all on the same page with the guardian or conservatorship about what they want to do. But in the background is the probate court saying, this looks fishy to me. I don't want you to do that. All of my guardianships do this, you have to do this. So you lose control even within the family because you're in the background of all of this is the probate court judge. And that varies a lot from county to county as well. Sometimes they do specific things in every county, and I just know going in saying this is what we're going to have to do. They're time consuming, so I've already mentioned with the court, it takes forever to get in there. I know the latest thing that I filed, I think it was about 5 to 6 weeks before I'm even able to get a hearing on my first thing. My first initial, before I can get in front of the judge. So that's time we're losing, and in that time, we're also losing money. So on average, it takes about 3 months to obtain a guardianship. So in a circumstance where we're in a nursing home at that point, let's just take roughly the average. So the average cost of nursing home care in the state of Michigan is $9,880. Let's assume that you're not in the average nursing home. Let's assume that you're paying a little bit more because we like a nicer facility. So let's assume we're paying $11,099.04. Very specific. I'll have to talk to Bob about this. It's very specific math. That times 3 months is just under $30,000. So that 3 months that it took us to get a guardianship in place so we could move forward with doing things, or conservatorship, has cost us $30,000. And that's not even including the attorney's fees and the guardian ad litem fees and everything else that we have to pay in order for this. So the cost of a power of attorney, well worth avoiding this headache if possible. And we can't avoid it in every circumstances, but in the vast majority of circumstances, we can avoid this. Just by having the very most basic of documents, those powers of attorney. So powers of attorney, I've kind of beat this dead horse, but there's a couple of things that I want to go into this as well. So types of powers of attorney, there's financial. When I say that financial powers of attorney are not built the same, I mean that. There are specific and general powers of attorney. So an example of a specific power of attorney would be like, I want Wendy to be able to attend my closing because I don't want to go sign 8,000 documents when I'm selling my house. So I want Wendy to be able to go sell my house. So I sign a power of attorney that allows her to only do that. That's a specific power of attorney. I've seen specific powers of attorney saying, I want them to be able to deal with my 401k, sell my house, sell my car, specific things like that. There's general powers of attorney that encompass a broad things, but just because it's general doesn't mean it necessarily includes everything. Generally speaking, if you ever come across a power of attorney that's like 20-some pages, most likely it's a general power of attorney, but we still have to look at what each authority allows you to do. Because maybe you have the ability to sign checks, but you don't have the ability to close accounts. So those are all things that we have to look at. Powers of attorney could also be what we refer to as springing or effective immediately. Springing generally means that it doesn't take effect until there's a triggering event. So healthcare powers of attorney, for example, are springing. You get to make your own medical decisions in the state of Michigan until 2 medical professionals determine you can't make decisions for yourself. That is a springing power of attorney. I retain that right until doctors determine I can't. Financial powers of attorney can be springing or effective immediately. We just have to look at the documents and see what's happening. So there's been times that I have to clear up that confusion to say, because someone's son or daughter is coming in, they say, look, I'm helping dad, bank won't let me do it. I look at it and I go, okay, it's a springing power of attorney. We need these things in order for you to help mom or dad. If it's effective immediately, it generally means upon signing, it's effective. The healthcare power of attorney, like I said, by nature it's springing. There's no other way to do it in the state of Michigan. The other thing in the state of Michigan is the healthcare power of attorney allows one agent at a time. I've come across powers of attorney sometimes that are allowing multiple agents. If you look at the statute, it means one. It says one agent has the ability to step in your shoes. Now, any good attorney is going to build in backups. I never hang my hat on one person. I always like to build in backups. But I've seen some powers of attorney that sometimes people push back on because it doesn't necessarily comply with the letter of the law completely. Mental health, this is one thing people don't think about, and we spend a fair amount of time in our office kind of explaining this when we talk about mental health. So people automatically think we're talking psychiatric disorders, right? Like schizophrenia or other types of psychiatric disorders that might cause issues with the way that we think. But those of us with experience with dementia and Alzheimer's know that a lot of times somebody has a complete personality change when they have an Alzheimer's or a dementia diagnosis. And physically, they're fine. But they leave the stove on when they leave the house, or they're driving and get lost, or any number of things that are happening that's not a physical manifestation, but is causing a safety concern. But it's all in our mind. So we have to specifically authorize the people we love and trust to get us help if that's the circumstance. And not all healthcare powers of attorney include that, so that's something we have to look at to make sure that we're giving agents authority for all of that. This is like one of my favorite topics. I could talk about this all night, but you guys have better things to do than to listen to me talk about all the different powers of attorneys. I'll just make sure we hit the main part. Privacy waivers, this is something I feel like most people also have an interaction with. This has to deal with the flow of medical information. So how many of you are familiar with HIPAA?
Nothing better than when you're trying to call up and schedule an appointment for your spouse and they're like, I'm sorry, we need to talk to your husband. Okay, well, my husband hasn't scheduled an appointment for himself in 10 years. So I really need you to work with me on this. HIPAA is one thing I think that most people have encountered, but it becomes really important, especially as our children are helping us maybe with appointments or just bringing a second person into our doctor's appointments to make sure we're hearing things appropriately. Having those people on a HIPAA release or a medical waiver that have access to your medical information so they are at least in the know is really important. So we always want to make sure that we're building that in as part of this as well. All right, so what do we need to do if we're concerned that we have a power of attorney and maybe it's from 1995 at this point, we haven't looked at it, we don't know whether or not it's sufficient. General rules of thumb that I recommend for anybody that comes through our office. If nothing has happened with the law or the family and everything has stayed the same, on a minimum, I recommend at least every 2 to 5 years we look at our powers. Because maybe you don't know that an area of the law has changed. I know I spend a fair amount of time on this just from the different boards and things that I'm involved with, so I'm aware of these things coming down. A lot of people aren't. So if you think everything's fine, there might be an update in the law that you're missing. Then the Michigan Power of Attorney statute hasn't been updated since 2010, but I've already kind of indicated there's some changes that they're looking at. We're anticipating in the next couple of years there's probably going to be a major change to that law. So we want to be aware of that and look at all of these. If we have a diagnosis or we are concerned about a diagnosis, looking at our estate plan to see if it has the flexibility or the planning to be able to account for that. Do we have those channels that if something happens to my spouse and I have a dementia diagnosis and I'm not sure where I'm going to be at in 5 years, does my plan account for that? Maybe I put my daughter in charge because she was the one that I trust now, but she lives in Alaska. She's not the most accessible person. Maybe I want to update that then because the circumstances have changed a little bit in ways that I haven't necessarily thought of. So those are all things that we want to look at. We want to be as proactive as possible because what I've typically found is by the time something happens to raise that little panic monster in the back of our head to be like, maybe we should get this looked at. It's because something already negative has happened. Whoops. Thanks, Wendy. Yep. Wow, I went real far. Yeah. All right. So those are all things that we want to be as proactive as possible because unfortunately when it comes to the law, a lot of time is money. And if we're losing time on a crisis because something didn't work out a certain way, then we have to adjust for it as well. But really what I found is most people want to make it as easy as possible on their kids without having to go in front of a judge. And we can do that just by looking at our documents more consistently. In our office, sometimes I explain when we do updates, I say, this is a very expensive paperweight if we don't maintain it. And I don't ever want anybody's documents to be a very expensive paperweight. I want to make sure that your plan works with you. So those are all things that we need to kind of be proactively looking at. So again, I said, even if nothing has changed in your life, 2 to 5 years, it doesn't help or hurt to have our documents looked at. This is just an example of a testimonial from our office. So in 2013, Alice's husband was diagnosed with Alzheimer's. Manor Law Group's legal expertise is rock solid, and I just don't know what I would have done through all of this without them to call on. I believe that anyone who works with Manor Law Group on any level can do so with confidence. That's always the type of experience I want people to have with our office, but even if you don't work with our office, still having a very knowledgeable certified elder law attorney is going to be helpful. But making sure that they look specifically at these issues. So the legal documents, before actually I get into that, I want to just touch on a couple other things with the legal documents. Your estate planning does not have to be overly complicated for people. That's what I think is one of the barriers sometimes of people coming in is they're afraid that it's going to be too complicated or it doesn't make sense. When you're planning for flexibility, it appears more complicated than it has to be. But we're really dealing with kind of one thing at a time. The circumstances that they are right now, that's what we're dealing with right now. If circumstances change, then we have a way to pivot. So they don't have to be super complicated.
I know we do a lot of education in our office, so we're always kind of using silly little pictures to explain all of these different things. But that's probably the one thing that I want to put out to people is that it doesn't have to be complicated. Now, you need a lot of tools in your toolbox, but it doesn't mean you need to use all of them at once. We just want to make sure that we can adjust to those as things change. But the legal planning isn't just the end-all, be-all to navigating a healthcare crisis. In our office, having the legal expertise is definitely helpful. Helps me be able to navigate all of these things, but I'm not the only expert in our office. We have lots of different experts in our office, and most of them aren't attorneys. So that brings us into our action step number 2, putting together a team of dementia knowledgeable professionals to work with us. And this could be a variety of people. So in our office, I've mentioned we've got a couple different experts, and they're all fantastic in their fields. So we're not like other law offices. We actually have social workers on staff. We refer to them as our elder care coordinators. They have nursing home facility backgrounds where they used to work in the nursing homes as social workers. They're really good at being able to navigate figuring out that process. So you have a loved one in a nursing home and we're having maybe care issues at that facility. Mainly we're having not getting the team of professionals on the facility take up. Or maybe we've got a circumstance where we're yo-yoing facility, hospital, home, facility, hospital, home, and trying to navigate all of that for stability of the person that is going through that crisis. So that's where we have a team of knowledgeable professionals that know how to navigate the healthcare system and specifically the facility system to know the rules, what your rights are, and when to push back and when to be nice. They make my job much easier because then I don't have to get in. Because a lot of times when we have attorneys coming into these areas, people go, oh, attorneys. We don't sue people. If I do, I'm typically suing the state of Michigan because it has to deal with some other kind of an issue. But it makes people on edge versus having somebody that knows that facility, is one of them, and can help navigate all of those headaches. Just some other examples of what we mean by team of professionals. So the medical is one end of that. So having somebody that understands the hospital navigation, maybe also getting into a team of doctors. So in our office, we have a great network of gerontologists that we work with or neurologists that we commonly refer to. So if you're having a problem, we can help pinpoint you in the right direction to make sure that you're seeing the right professionals and getting a good diagnosis. A lot of times people don't think about the diagnosis being an important thing, but the treatments can be vastly different. So the treatment for vascular dementia might be completely different from Alzheimer's. So having that good diagnosis and being able to get to the right professionals to get there is important. The legal, I beat this one to death. You already know the legal stuff is important. What most people also don't think about is the financial though. If you work with a financial advisor, great. If you are your own financial advisor, great. What's important as part of this is on my team, I know that I'm going to have to work with a network of people because I don't hold everything in our office. So I've got my social workers that help navigate the nursing facilities and the hospitals. I work very frequently with financial advisors because they want to do a good job for their clients the same way I want to do a good job for my clients. And I know things that they may not know, and my social workers know things that we both might not know. So we'll all work together to make sure that this plan is working the way it's supposed to. Care can be another thing, especially if we're looking at just the care coordination in itself. So maybe it's where to find good caregivers or what facilities are better than other ones. Maybe there's a facility that's better for this type of dementia than another one. Just knowing what the options are and having a team of good professionals. I don't know everything. And I love working with good other professionals because most of the time they're just looking to do the right thing for you the way that we are. So the more that we can network and work together, the better. So having kind of that know-how is important. As I've kind of already said, putting the plan together is really the most important thing, and having that group of professionals that work together. So I know in our office, a lot of times when we have a new client that comes on, we're reaching out to those advisors. We're getting permission to do it first, but we're reaching out to those advisors to introduce us. Say, hey, this is what we're doing. We'd love to work with you on this. And we even do this on a pre-planning side when it comes to things for the estate planning.
The more people I network in your life, the better I can serve you. So that's what's really important for us. The strategies becomes the really important thing, and that goes back into the whole I can't do everything by myself. Even my team, we can't do everything by ourselves. So we need to work with your group, your trusted advisors. All right, action step 3. Learn what care options are available and how to pay for that care. This is probably the area in which there is a lot of misconstrued information. So it's not necessarily bad information or wrong information, but all of this is very circumstantial. The experience that your neighbor had, or your pharmacist had, or your barber had, those are probably 3 very distinct experiences, and what the individual was dealing with, what their family makeup was, what kind of documents they had, what kind of assets they had to protect. All of those are very different. So there can be a lot of bad information out there. So I just want to give a real kind of high-level introduction to what a lot of this stuff is, just so we're aware of the different benefits that are out there. So when we talk about types of care that are available, a lot of times we just kind of, for ease purposes, let's separate it into in-home care versus facility care. So the types of care in-home, maybe we're relying on family caregivers. Maybe you have a child that is retired or is on their way out and they can afford to leave their job in order to be a full-time caregiver for you. There's some missteps in there, and we want to make sure we do things appropriately. There's a lot of well-intentioned people that are trying to stay out of facilities, stay out of benefits longer, and make some missteps. So this is something we commonly advise on, is how best to set up the structure for family caregivers. So everybody is on the same page, everybody knows what the plan is. That's one option. Maybe we're not relying on family caregivers because that's not really the best option, and we're looking at home care companies. Same type of thing. We want to know what benefits are available. Maybe you have a long-term care insurance policy that helps cover some home care. Maybe there's other benefits that we're looking at that help cover home care. Knowing what is the appropriate home care, how much home care, what services that they should be doing, as well as having all of that documented as well. And there are some fantastic companies that we work with and refer to as well. Maybe it's just other people. So I've encountered this a lot where it's just really the neighbor's there, the neighbor looks in on mom or dad, they're making sure everything's getting done, or a lady from church. Could be any other kind of support network that's coming into play for home care. So there's a variety of things that can pop up for home care. There are some missteps in here that good intentions can kind of affect your legal planning. So if we're ever considering that, a consult with an attorney is very worth it, because you don't want to make those missteps and try and get out of it. When we're talking about facility care, this is the area that often gets blended in. So I want to spend a little bit more time talking about the different types of facilities. Independent living, assisted living, and memory care, nursing home, skilled care. Those are 3 distinct facilities types. Now, there might be certain communities that have all 3, and that's where it gets even more confusing to know what kind of facility that you're in. Independent living is, we describe this typically as you have, 2 checks. So you have your room and board, you have your apartment living, and maybe you're paying for a little extra care. So maybe you're paying for medication reminders or extra little care things that are part of it. So you're living in the independent facility to have that kind of a network. But you're still maintaining your independence. You're still doing whatever you possibly can. But these are typically a little bit more structured to help ease that transition. So independent living is typically not an area that we're seeing any kind of benefits from. So you're typically private paying as part of this independent living. Assisted living, memory care. These are the same thing. I know sometimes people will be like, oh, they're in memory care. Memory care is not nursing home level of care. So they're very distinct things, but assisted living and memory care are the same type of facility. They're both forms of assisted living. This is where we're needing more care, but we still want to maintain a little bit more of an independent environment. So we've got some assistance. We've got the care team. We're paying for services. And there's a lot of different types of services that are offered at different facilities. It could be like an all-inclusive, or you're paying by service. Really kind of just depends on the facility that you're looking at. The benefit programs are also limited in this area as well.
There are some that help kind of offset some of the cost of care, but it's not going to cover everything in most circumstances. So a lot of times there is a portion of private pay. And then we have the nursing home or the skilled care. So this is 24-hour skilled nursing care. So this is the nursing home that people typically think of. There are more benefit options to help pay for this, but this may not always be the intended place that we want to go. But it's important that we understand the differences between them. So when we talk about the benefits that are available, these are a broad overview of the benefits that are available to help offset the cost of care. So over on the far left, right, my left, we've got private pay. So this is always an option for those that have the ability to self-fund or private pay for their care. And maybe we're doing this for a period of time because we're in that assisted living or maybe even the independent living, and we're able to private pay for a period of time. So that's when we're fortunate enough to self-fund. So if any of you hit the Powerball the last time, you probably can self-fund. You have other problems. You have tax planning problems. Veterans benefits is another option. There's a lot of different kinds of veterans benefits. They just kind of depend on your service record, what kind of benefit you're qualifying off of. So if you're qualifying based off of some kind of service-connected injury, so if you were injured in service, there's a different set of benefits that might be available than if you weren't. There might be one that's just this aid in attendance program that is available to a qualifying veteran. You don't have to have been injured in service. You just had to have served 90 days, 1 day of which has to be in an eligible wartime period as set forth by Congress. Don't ask me the dates. I can't ever remember them because they shift them around periodically. The easiest one is the Gulf War because that is technically still going. They haven't ended that one, so all of our veterans currently are Gulf War veterans. But that is a service a benefit that's available to help pay for the veteran or the spouse or both to help receive some additional care services. So they have to meet some eligibility requirements. There's an asset test, and there is an income test as part of that. But those are some entries as part of that we look at, we consider. But those can sometimes help offset the cost of our care. So maybe we have a smaller amount that we're private paying. If you've got a service-connected injury, there's a possibility you might get nursing home services as part of that. That really has to look at your level of injury. But those are all things that we look at as well. Long-term care insurance. If you were fortunate and you had the foresight to purchase long-term care insurance, that is fantastic. Most people I found don't have it because this wasn't really a common product back around the time that most people were buying it. But if you do, it's great. It's one of the things that we look at. It may not cover everything. Sometimes they only cover home care, or they're only going to cover a nursing home stay. So those are things that we have to look at when we're evaluating all these different types of benefits, is what that long-term care insurance will pay for, how much will it pay, and for how long. All things that we can look at as part of this. The last two here on the right, Medicaid and Medicare, often said interchangeably in my office. They are distinct programs. Medicare is typically the program that we have paid into. So we paid into our Medicare system, and then once we turn 65, we get on Medicare. And that is our primary health insurer through the government then. And there's a couple different kinds of Medicare. We're not going to get into that today. But Medicare will not cover, if you get one thing out of here, this is what I want you to get out. Medicare does not cover long-term care services. It will cover short-term rehab stays. So you might have a circumstance where you broke your hip, you went to the hospital and then to a facility for a period of time for rehab, for rehabilitation. Chances are that was covered by your Medicare benefit. If something happens where you're not able to go home after that rehab stay has ended, and they say you get up to 100 days under that Medicare benefit. I have not seen that 100 days like ever recently. Typically we're seeing about 4 to 6 weeks maybe. You're not getting the 100 days like people used to. You might get that 4 to 6 weeks, but that's probably the max that you're going to get. And you can appeal and you can fight, but I'm not seeing those long-term care benefits stretch out as much. If we've got a circumstance where someone has to stay in a facility longer than that because it's not safe for them to go home, or we can't meet the care needs at home, we don't have an environment that works for that, chances are what most people are looking at to get qualified is long-term care Medicaid. When you look at Medicaid, there is 1,000 different programs under Medicaid. When we talk about Medicaid, we are specifically talking about long-term care Medicaid. And there's a couple of different programs for Medicaid when we talk about long-term care. There are two that are more community-based, and that is referred to commonly as the waiver program, and where that helps provide some additional care in-home. And then there's another program called the Program for All-Inclusive Care for the Elderly, is the PACE program. Both of those are more community-based programs. They have different restrictions on them. Specifically, they have an income cap on them currently. So if you make 1 penny over that income cap, you will never qualify for those home-based services. That's what's important to look at when we're trying to navigate all of this. Because your neighbor might have qualified for the waiver program, but your barber might not. And those are all things that we look at. And then when we're talking about nursing home care, that's the other type. So that would be the facility type Medicaid that we're looking at. So these are common questions that we get when we hear people being concerned about Medicaid specifically, or the cost of a nursing home. Because we've already indicated cost of a nursing home is just under, average cost of a nursing home, just under $10,000 in the state of Michigan. Probably is higher than that, just depending on your need and the type of facility that you're in, but the average cost is $10,000 a month. So, what can the nursing home take without good legal planning? So if we don't have good legal planning, we're stuck with the default rules, and the default rules are not very kind. With married couples, you're able to keep more assets than if you're a single person, so you do have some ability, but almost all of your assets are subject and available to be used for the cost of your care. Now, it's not that the facility takes it. It's not that the state takes it. So they require you to spend down your assets till you're under that threshold. The last bullet there surprises a lot of people. If, I'll just use myself as an example. If my husband needs nursing home care, all of my assets are included as part of that initial determination. Doesn't matter if things were separate, if it's mine versus his, and we've got some things that are joint. They look at us together, even though he's the only one that needs the care at this point. So it's one thing I think that surprises people a lot is that, well, we look at you guys together, and those are the rules that we're dealing with. For a single person in the state of Michigan, you're allowed to have a house, car, very small life insurance policy with a face value of $1,500, and $2,000 worth of assets. So if we look at this and say, okay, well, they allow us to keep the house. They allow you to keep the house. And from your income, they leave you $2 a day, so $60 a month, roughly. $60 a month trying to pay your home insurance, trying to pay your property taxes, trying to pay your utility payments. I don't know about you guys, my consumer's bill was a little bit more than $60 this month. So even though the default rules allow you to keep these things, they don't really leave you with much to pay for it. That's why I really don't like to see anybody be stuck with the default rules, and being as proactive as possible helps us avoid that. So how do we protect our spouse? Having that specific planning in place. I mentioned that the rules are much more favorable for a married couple. Married couple, we can typically protect all of the assets while they're a married couple. But if those statistics come into play, where the healthy spouse passes away, where does all the money typically go? To the spouse in the nursing home, who has to spend all or most of that money down. Single person, we're looking at somewhere between 50 to 100% of protection, depending on the assets and what we can work out at that point. 50% of your assets aren't fun, but when compared to qualifying on that $2,000, it's better than not doing anything. But if we know that's a possibility, we can do that planning to prevent those assets from ever going to that nursing home spouse. So we can make sure everything is set up that if something happens, we've done everything we possibly can to keep the money protected, to help them qualify for Medicaid sooner, and not having to do a spend down. Because unfortunately, money gives us options, and money gives us a higher quality of life. So when we talk about asset protection, a lot of times people think I'm talking about protection for the kids. That's kind of a side effect of good estate planning that's helpful. But when it comes to me doing planning for my clients, I'm making sure that you have as much money as possible because that gives you a higher quality of life. Because if we're on Medicaid, that'll cover our nursing home care, and they're going to leave you $2 a day. Nobody should have to live on $2 a day. It's not a high quality of life. You didn't work your entire life for this in order to qualify for Medicaid and be stuck with $2 a day. $2 a day won't even get you anything on the dollar menu at McDonald's anymore because it's more like the dollar-ish menu now at this point. So we can do planning to make sure that if something happens to one of the spouses that we've protected as much as possible. What about the house? The house is most often the most valuable asset. House or retirement, depending on what's going on, those are probably our two biggest ones. When we're talking about the house, it's our most times our most valuable asset. What can we do to protect the home, even if you need care now? So if you need nursing home care tomorrow, what can we do to help protect the assets? And there are a lot of things that we can do in order to make sure the home is protected. So those are all things that good estate planning can do, and that's why it's important to kind of look at all these things from not only the estate planning perspective, because I am an estate planning attorney, but I'm also an elder law attorney. So I'm looking at these things that I know things could go wrong, and this is a strong possibility of happening, so I'm going to plan for that. All of my estate planning clients, we do good estate planning, but then we also look at the elder care lens in mind. So how do we protect our assets? A lot of this is about putting the puzzle together. So I think probably one of the other more common questions that we get in our office is how are you guys hiding the money? First and foremost, we are not hiding the money. We're not putting money in mattresses or shuffling things around. We are taking advantage of the safe harbors that are built into the law. It's the same way that the billionaires pay less in taxes than we do. Most circumstances, they're not doing anything illegal. They're taking the tax code and they're using it to their benefit. We're taking the Medicaid laws and we're using it to our clients' benefit. We're letting Medicaid know where everything's at. We report all of the assets. We say this is how it is. But then we tell them based on your rules, this is how you're able to calculate it. So using those safe harbors is what enables us to help protect our clients' nest egg and make sure that they have that quality. Spousal protection planning. This is kind of our way of explaining what I talked about as far as if something happens to one spouse and the other one needs care, we don't want all the assets to end up with that person. So it's using that kind of frame of mind to structure the estate planning to make sure that it goes the right way. If something happens and the healthier spouse dies first, that we have a plan to make sure that the spouse that needs long-term care isn't going to receive all those assets, because then we're looking at that 50% number, right? We don't want to look at that. We want to look at a better one. Planning for a single person. This may not sound like it's something that's feasible because, like I said, $2,000 worth of assets is all that you're allowed to keep of countable assets. We can still do really good planning for single individuals. So if dad passed 10 years ago and mom needs care now, we can still look at protecting the assets. Like I said, we're in that 50 to 100%, depending on what the circumstances are, but those are things that we routinely look at in our office as well. Because the Medicaid rules are less favorable and more easily able to mess up, that's something we routinely look at in our office as well. The stuff in yellow I want to get in that. This is the good intentions that went wrong. And a lot of times this is not even you trying to avoid reporting things to Medicaid. It's you wanted to make your life easier and we wanted to do things as easy as possible. Easy doesn't always mean that it's a good solution. So some people talk about, well, just in the event I need a nursing home, I'll just take all of my assets and I'll give them to my kid. Problem solved. I'm under assets. They've got it all. It's not my money anymore. We don't want to do that. That is Medicaid fraud. So we can protect the assets without doing that. And what we end up having to do is undo that transaction a lot, and hopefully the money is still there. Sometimes it's not, in order for us to fix that, but those are all things that we want to look at. The second bullet is probably the primary thing that I'm correcting as an estate planner, is adding kids' names to accounts, because we wanted to make it easier. We didn't want to go get a power of attorney. I want to make sure that my daughter can help pay my bills, so I went down to the bank and I added her name to the account. Problem solved. If I can't pay my bills, she has access to the account. A
couple things people don't think about until it goes really wrong. Your daughter could be the best person in the world, but maybe her husband sucks and they're getting a divorce. Well, if her name is on that account, he could claim that that's part of the marital assets. And maybe you'd win in the long run, but how much money is it going to cost to say this isn't part of the marital assets? Or maybe she made a mistake. She got a judgment against her. Got creditors knocking down the doors. If her name is on your account, and I used to do this work early on in my career, they can go after your account simply because her name's on it. So you hit a garnishment, sucks out the account because she owes $30,000 on some credit card she forgot about, racked up. Maybe her husband racked it up and her name was on it. That happens too. And Capital One just took all your money. Legally, they don't have to give it back. So then we've exposed that money to that. If it's not that, sometimes you just have to unwind the whole thing and you have to explain to Medicaid to say, look, I put her name on the account. This is really my money. But then you have to jump through all of these hoops, just taking more time to explain to them. So please, this is if you only get one other thing besides the Medicare not covering long-term care, if you get the second thing, please do not add your kids' names to your account. There are better ways to do it. The power of attorney will effectuate the same thing, or sometimes we use the revocable living trust to do the same thing. That is a better plan because it does not expose your money to what your child might be doing. Your kids can be the best person in the world, but if something happens and someone's able to get into their account, the chance of you getting money back once it's gone is very, very low. So we can protect it by not going through that. In a lot of our estate planning seminars too, we also talk about the 4 Ds. So I already kind of alluded to 2 of them. Divorce, the son-in-law that's just awful and you can't wait for your daughter to get rid of him. Or debt. So both of those are exposed. But I also want to talk about disability and death. So if your kid is the one that you add, let's talk about death first. If your kid is the one that you add to the account because they're the ones that are going to help you out. Unfortunately, we saw the magnitude of this over the last 4 years with the public health emergency, the pandemic. Your son is the one that helps out with everything. Your son is the one that you can rely on. If you can't pay your bills, your son is the one that does it. He's on the account. You have an Alzheimer's diagnosis. He's been the one managing your funds. He dies. What happens then? Who's going to step in and make it? Most of the time I'm looking at guardianship and conservatorship for that end. Or, hopefully your name was on the account. If your name wasn't on the account and we just shifted money and we left it in his name, that then goes to his estate planning. Hopefully you have a good relationship with your daughter-in-law or your grandkids at that point. Because if the money shifts to a different place that we did not intend it to, that causes a bunch of issues. Even if it didn't shift, but they're your primary person, how does that affect it? And there's been several instances over the last couple of years where I've seen somebody's child predecease them and there's no backup. And it doesn't need to necessarily be a worldwide pandemic. It could be a car accident, a heart attack, whatever. So having those backups are really important. Disability, this is one thing I think people just don't think about too often, and that is disability really goes a wide range of things. So we could be talking about disability in terms of government benefits. So if you're disabled, you're not able to work, you maybe didn't have enough work history, you're receiving government benefits because of that. So you have a child that was born never able to work. They've been on disability their entire life. Chances are, if that's the circumstance, they're on a needs-based system. Good estate planning will take care of that. We'll make sure that you doing good thing of leaving them money doesn't affect their benefits. But if something happens simultaneously and we don't have a plan in place, we might be looking at a spend down for them as well. And there are other circumstances that it causes a headache. Good estate planning will always address those 4 Ds. It will always have contingencies for death, divorce, debt, disability, death. All of those will be taken care of as part of good estate planning. But it's kind of that worst case scenario. And Wendy makes fun of me all the time because I live in the worst case scenario. I assume everything is going to go wrong. It makes me really fun at parties, according to my husband, when I'm Debbie Downer over in the corner. Well, if this happens, then this. It makes me a really good attorney
because I know if things go wrong, I have a plan for it. Now, my hope is that I am wrong and you are in the best case scenario. But I would rather be wrong than be right and not have a plan for you. So we always want to look at all of those different things when we're talking about estate planning, especially in this context. So what if we didn't plan ahead and we need care today? What are we stuck with? Are we spending down everything? Are we stuck with that guardianship or conservatorship? The answer is you want to meet with an attorney as quickly as possible before any decisions are made. Because once we make decisions and move forward on plans, we have to pivot. That's more challenging. So what you guys can do as soon as possible is consult with an attorney. Maybe mom and dad's documents are fine, or maybe your documents are fine. But you won't know that until you meet with an attorney. And if their documents aren't fine, the sooner we get involved, the better. We can adjust from there. But there is no such thing as too late when it comes to this. There's proactive planning, which we've spent the first hour or so talking about. But then there's also crisis planning. And crisis planning is really what our office specializes in. I mean, we do a lot of the protective planning, but we do a lot of the crisis cases, which a lot of elder attorneys actually don't do. Some of them only want to do the pre-planning. The crisis cases are where we can get our team involved, so legal, financial, healthcare, all of them, care coordination, all of them together to work and navigate that process to make sure we have the documents in place. It's a huge part of my job on a day-to-day basis is going through all of our life care planning clients to make sure their documents are set up the way that they're supposed to. And the sooner I get involved in doing that, the better. It's one of the very first things that I do when we're hired. But it's no such thing as too late. So I never want a family to assume, well, this is what we're stuck with now. You always have options. It may not be the greatest all the time, but you have options. So we want to look through all of those. So we want to put a plan in place, and the sooner you do that, the better. And if our office is a great fit for you, then that's something I definitely want to welcome. We're always looking to help people as great as possible, and education is a huge part of what we do. So if anything, if you've gotten those 2 nuggets today, then I'm happy. I've served my purpose in giving you some additional information. But we really want to put a plan in place, and the sooner we do that, the better. Just another example from Linda from Troy. Manor law helped my family through a very stressful time with 2 aging parents. They were both World War II veterans. We needed to make a transition to long-term care. Both parents received VA benefits and were able to be placed in a very nice long-term care facility. Manor law was efficient, prompt, and caring of our situation. We'd highly recommend them to anyone who is dealing with the elderly. So how do we make that happen? You, of course, can schedule a meeting with our office. One of the benefits of having attendance here today, so listening to me drone on for the last hour 45, is that you get the benefit of talking with our office and having that strategy session and not having the obligation to move forward on anything. So how this basically will work is if you want to schedule today, Wendy, my lovely Dana White in the back of the room there, is able to schedule appointments today if necessary. What this typically is a 1-hour strategy meeting. We can do them in person in our office in Grand Blanc or Rochester. Some people prefer not to go out right now. I don't know if you've seen it outside. There's yucky stuff. I just got back from Tampa on Sunday. I wish I would have stayed. It was much nicer there. But in the event, it doesn't make sense to come to our office, or if you want your kids to be involved and they live out of state or not super local. Pandemic has taught us many things, including how to be very effective on Zoom. So Zoom, telephone call, all of that's possible. But what we typically do in this meeting is we look over your estate plan documents to make sure it does all the things that I'm looking at, to make sure we've got a plan in place. And if it doesn't, what my recommendations are for moving forward. Developing a plan for that second half of life. As I indicated earlier, the estate plan you had in your 20s, 30s, 40s, 50s probably is not the estate plan you need in your 60s, 70s, 80s, 90s, 100s. Those are all things that we need to be able to grow and change with us. It's a living, breathing thing. We can also answer your questions about your unique circumstances and your individual family. Maybe you're concerned about one particular thing. Maybe that son-in-law that's just awful really touched home with you. Feel free to talk to me about it. but we can look at your unique situation and come up with a plan from there. So once we're done with that strategy session, you would know what documents that we're recommending for you. Most of the time, like I said, those powers of attorney are usually what we're recommending, but there might be some other things to look at. Your options for Alzheimer's and dementia care, because this is kind of unique, but not even just Alzheimer's and dementia care. Maybe there's another diagnosis that we need to be aware of. Any of the health concerns, we can make recommendations for how to address that. Maybe it's not your health concern, but maybe it's your child's. And making sure they're not losing those government benefits that we talked about, making sure that you're leaving them money with people we trust to manage all of that. And what we alluded to earlier, that peace of mind. Peace of mind that, you know, your loved ones will be prepared that if something happens, they have a resource network to come through. What we tell everybody in our office is that we don't look at this as a transaction. I don't just do documents for you and never see you again. If that's what happens, I'm assuming everything is great, but if that doesn't happen, we want to be a continuing resource for you. So it's always someone that you can call back to if circumstances change. You, your health, your family, you read something in the news and you're not sure if the law change affects you. Those are all things that we pride ourselves on updating and being really a network as possible. And that's largely why we do this. Bob does a ton of presentations. We've got a ton of webinars and materials if you're ever curious. Our YouTube channel is full of them. But the education aspect is really what we love doing, is teaching people. So after that meeting, we would develop a written plan with our recommendations, work with you to implement the plan, any of those legal documents. We have a variety of services in our office, just depending on what you're looking for, from the basic estate planning to that elder care coordination. In our office, we refer to that as life care planning. It's a plan for your life and your care. So that usually has a stretch of the legal side along with the holistic care coordination side. And that's where our social workers are involved with. We'll prepare any legal documents and make sure that they are executed properly. So I'm not just going to send you legal documents and be like, Godspeed, hope you notarize them correctly. All things that we supervise in our office and make sure that it's correct. And most importantly, we're going to walk you through that process start to finish. So if it's an estate planning matter, we're going to walk you through start to finish and make sure everything is covered. If it's a crisis situation or a long-term care side, we're going to walk you through that. And that process is like eating an elephant. We do it one bite at a time, because otherwise you'll glaze over and put your head in the sand, because it's a very complicated system to navigate. And that's why we have people in our office to help do that. Because not everybody worked in healthcare their entire lives or worked in the legal field their entire lives. That's why we have people to help guide us. One final testimonial here. We met Manor Law after looking for a certified elder law attorney to help with my elderly mother, Bessie. They answered all of our questions, some of them multiple times, which we're always happy to do. They were clear about every cost, which we were anxious about walking in. The office staff is also very helpful and knowledgeable. One thing with our office is we largely operate on flat fee. So you'll know what you're paying, what the obligation is. That strategy session is no cost, and you would leave there knowing what the cost of our recommendation is. So you're never going to be surprised by something. If something does pop up, we always let people know. I've been in the circumstance where I was like, hey, by the way, we found this out. It's going to be this. And I always like to talk people through all of that stuff. But for the most part, you'll know exactly what you're paying for when you leave. Typically that strategy session, actually we got to update this number. Our office lost power about 15 minutes before I left here today, so I wasn't able to update all of this. The strategy session, which would normally be about $400, that says $350, you can book for free today. So that's one added benefit. Again, not something you have to do, but if you're interested in at least getting some good ideas, come. No obligation strategy session is part of that. What's the catch? There really is no catch. What it is making sure that you have a resource network. And if we're a great fit for you, that's awesome. I'm glad that we can help out as many people as possible. If we're not a good fit for you, then that's perfectly fine. Then you know we're not a good fit for you. And maybe there's somebody else that I can point you in the right direction to. Maybe you don't need an attorney, you need a financial planner. All things that I can help, or in our office can help navigate. So to book your session, like I said, if you wanted to today, you could do that. For those of you that are tech savvy and like to be on the phone before I'm even done talking, you can actually book it via that email website address, calendly.com/manorlawgroup/free-call, or you can call our office. So even though we have no power in our office, we still have people answering the phone. We made sure of that before we left today. Hoping power will be back on tomorrow, but that is something we'll be able to answer the phone as well. If it's after hours and you leave a message, we will get back with you as soon as possible. But we are available in a variety of ways. So you will know what documents that you'll need as part of that session. You'll have your options for care planning. So if it's Alzheimer's, dementia related, or some other kind of condition, you'll know that. And that peace of mind. The strategy session. I would have removed these had I had power at the office. That's it. Any questions or concerns? We've got plenty of time for questions if anyone has anything. Yeah.
In getting the power of attorney, how cognitive does the Alzheimer's person have to be?
So we talked about this. There's two different thresholds that I'm typically concerned about. And the terms are used interchangeably, which is frustrating sometimes, and even in our office, we'll do the same thing. We're concerned about competency and capacity. When we're talking about competency is high-level decision-making. So that's being able to balance your checkbook, being able to understand the nature of your investments, and make decisions based off of that. The ability to make healthcare decisions, so to make an informed healthcare decision. That's competency. That's a higher threshold. For legal planning, we use a threshold called capacity, and this is what's built into the law. Testamentary capacity is what's used. For testamentary capacity, which is a much lower threshold, you don't have to understand any of those things that I just talked about. You don't have to understand what's a good investment. You don't have to understand the doctor explaining all the pros and cons to you. You have to understand some basic things. You have to understand who your family is. You got to be able to recognize them. Name who they are, so know who your spouse, your kids are. You have, and this is the funniest term, legal has a lot of weird terms, right? You have to understand the nature of your bounty. Yes, bounty, like pirate, your bounty. Which basically translates to you have to understand what you own. So you have to understand you have a house, you have investments, but you don't remember what your advisor invested in at this point. But you know you've got investments, you know you have a bank account, you know you have those things. And then you also have to understand that you can put somebody in charge to manage those things for you. So you may not understand all of the things that go into that, but you understand, this is my son. I trust that my son would make good decisions for this, even if I can't understand them for myself. That's testamentary capacity. That's what you basically need in order to execute your documents. So that's a lot of times we'll get people in our office saying, Mom and Dad, pretty sure they don't know what's going on. And we'll look at them, we'll go through. I don't go through in order of like, what's the nature of your bounty? It's more of a conversation. And from there, we evaluate whether or not they still have the ability. So most people assume that their parents can't. They meet with us and like, actually, they're fine. Yeah, they may not understand that PNC changed owners 3 times. Who does? I have a hard time following that myself. But as long as they understand those things, generally speaking, they have capacity. And it still will be evaluated by us. We try and evaluate it. But the vast majority of time, I would say most people think that they don't have capacity when they actually do. And it's because of those 2 standards.
And if they don't, what do we do with that when the courts?
Capacity is a fluid thing sometimes, too, to keep in mind. So you can have, especially when we're talking about Alzheimer's, dementia, mom or dad might be fine in the morning. They can tell you the street that they lived on and what color their front door was when they were growing up. And in the afternoon, maybe don't recognize who you are, maybe think that you're their sister or aunt or something like that. So it can come and go. Capacity can up and down. The only thing that matters to me is when I'm evaluating them is if they have capacity they understand at that time. So sometimes we'll have people say, oh, mom's having a really bad day. Okay. Well, when would be a better time to come and talk with mom? Because that's something we have to look at a situational basis. Now, if that's never coming back, if capacity is gone and it's not coming back, that's when we typically look at the court options. If there's an existing power of attorney, it might do what we need it to do. If it's court, there's a couple of different options that we go to. Maybe we only need to go to court to ask them for permission for one thing. So it might be a little bit easier of a process. But that's all stuff that we would kind of look at that point. And all this a lot of the lead up for that is very similar. Like all the steps are pretty similar. It becomes after like kind of the initial court hearing where things change. But that's all stuff that we can look at to see, okay, well maybe the setup is different and we can work with what we have before we go to court. Court is usually my last case scenario. There are some circumstances that we're actually using court as a planning tool. So that's an intentional thing to say, hey, we're going to court to do this. But when it comes to replacement of powers of attorney, that's usually something that's because I've exhausted every other option and it's really the best option that we have moving forward. But if we can avoid it, that's what I like to do. It doesn't always happen, but it is one of those things that we look at. Other questions, concerns? All right. Well, like I said, I will hang out around here. I do not have to absolutely leave to get my son from daycare for a little bit longer. So if you guys have any questions or you don't want to ask the group, I'm going to give you a very lawyer answer and you're not going to like it. It depends. So with the cost of it, it really depends on what we're looking to do. Like I said, you will know exactly what you're paying for. We flat fee as much as possible. But it could be anywhere from $650 to $20,000. It just kind of depends on what's needed. It's kind of like when you go to the surgeon and you say, or you go to the doctor and you say, my stomach hurts. They don't know if you need the $5 bottle of antacids or the $40,000 surgery. It's something that they just kind of have to look at and say, okay, based on the circumstances and everything going on right now, this is what you need. But like I said, as part of that meeting, it's not something that you're gonna have to try. We're not like a timeshare sales. It's not something you're gonna try and escape our office. We're very direct. We're very transparent. If we're a good fit for you, fantastic. I love helping people. If we're not a good fit for you, but I know someone who's a better fit from you, I'm gonna send it to them. Because I like doing good work for people. Oddly enough, there are not many people that say that they went to law school because they wanted to do estate planning. I was one of those weirdos in law school that said, I want to do estate planning. Helping people and educating people is what I love doing. It's what Wendy loves doing. It's what everybody in our office is really passionate about doing. If we're not the right fit for you, we will be perfectly honest on that. And if I think there's someone else that can do it better than we can, we will send you their way. All right. Well, thank you guys so much for coming out and spending time with us. Like I said, I will hang around with Wendy. If you have any questions, feel free to take your goodies on there. Bob wrote a book, so feel free to peruse that. It takes like an hour to read. It's got some really good information in there. But yeah, if we can be of any help to you guys, let us know. Wendy, any other remarks?
No, they don't necessarily have to even schedule an appointment with us today. They actually that phone call that we referenced up there, it's kind of like a triage call with me. So I'm gonna get to know you a little bit better and kind of get an idea if this is something we can help you with and if we're a good fit for you. Kind of figure out who's gonna be the best attorney for you to meet with. I'm typically in a lot of the meetings as well, doing some of the education on this stuff. So we need to figure out, are you looking to get estate planning because nothing is happening right now, or are you in a crisis situation? You know, depending on what's going on is gonna determine how quick we have to get you in our office and who you need to meet with. So
we do have 3 attorneys in our office. So there's myself, Bob, and then we have another attorney, Melissa Dixon. We are all very excellent in our different areas, but we all have slightly different backgrounds. So sometimes we'll put you with the right one. Yeah, sometimes we'll put you with, I have a heavy real estate background. So if you have real property or multiple pieces of real property, a lot of times you end up meeting with me. But all of our attorneys work together. So at any given point, we like you to meet multiple members of our team. In the event that I've got something going on, then at least you've got other people in our office that you can work with. But that is largely how we operate, as a very team-focused environment. All right. Well, thank you guys so much for coming out. Please feel free to take cookies for the road, because if you don't eat them, I have to bring them back to our office, and I will.
okay.
So do me the favor. Thank you so much.